breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence lawyer, not your typical pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters with Joe Crowley and Lizzie Green, a brand new weekly podcast. Our episodes are available on Apple Podcast, Spotify and YouTube. Check out our Instagram for clips at Justice Matters Pod. Enjoy the episode. This episode contains descriptions of rape, sexual assault, violence against children and murder. Listener discretion is advised.
So Joe, hello.
Hello, how are you?
Good.
You're very excited about this episode. You want to jump straight in?
Well, it's not that I'm excited, but I am a little nervous actually about this episode because I think it's quite a big topic.
Yes.
And I also think it's one that people have big feelings about.
Yes.
It's also a really hard topic to listen to.
Yes.
So I guess our warning about it being about sexual offences and rape is a big warning today, especially because some of these offences are committed against children.
Yes. And
they are upsetting. So I have wanted to talk about consent to sexual offences and rape as a topic for a long time. It's something that I teach and I feel like we need to all be aware of.
Yes.
But it was triggered this week by the fact that there has been a new campaign launched by the federal government about consent. And I have had a little bit of skepticism about some of the campaigns that have gone before. They haven't always hit the mark.
Yeah.
You know, it's a tough one to deal with. You know, what is consent?
Yes.
What's your responsibility in terms of getting consent? All of those things. But I quite liked the two ads that I have seen that have been released, and they have been developed in consultation with Chanel Contos, who we've talked about on earlier episodes, who's been very active in the sexual offending sphere.
Yep.
Also, to give credit, was National Association of Services Against Sexual Violence board member Catherine Fordyce and head of engagement at No to Violence, Lizette Twizzleton. Mm-hmm. So in consultation with the government. And so these ads are a little different in that they're asking these questions like, what is consent, but also what if you've been drinking, and what if they've said yes before, and you know the things that we know as lawyers really go to the heart of the issue when consent is raised in court. And it also goes a step further and says, as adults, we all need to be talking about this. We all need to have an understanding because how else can we teach our kids? And I think that's really important. And so what I want from today's episode is for people to have these conversations. You know, I have talked about consent as a concept with my kids since they were little, obviously age appropriate, but as we go. And I've been very clear that, you know, you are all responsible for ensuring that whoever you're with at whatever time is consenting, that there's no question in your mind or their mind, because I've seen in court how disastrous it can be where there's these questions that have not been dealt with. So then as I was looking into this, the other thing that I wanted to flag is that we have had some recent legislative reform relating to consent through the coercive control bill that has been passed but has not commenced. So as far as I know, it's aiming to commence these new provisions across that bill in July 2025. So it hasn't come in yet, but I also wanted to talk about that.
Yep.
But so I guess where it becomes a little bit tough to listen to is I want to explain why it's so important that these changes are effective and that people are aware of them, because the history of case law around rape charges and defences to that is very concerning. And so I wanted to give that history so that people have this understanding of, well, why is it such a big deal that it's changed? Why do we have to be all involved in this campaign, you know?
Mm-hmm. Yeah, all right, far away.
All right, so I guess when we're thinking about what what we understand rape to be. I guess traditionally or historically, it was this idea of force and violence in terms of sexual acts. For a very long time, our law only allowed for a man to be a rapist and a woman to be a victim because of the definitions that were in place.
Yep.
So it had to be that penile penetration, you know. We have definitely evolved in terms of what we understand this kind of offending to be. So there doesn't have to be violence. There doesn't have to be physical force.
No.
An offender can be a woman. A victim can be a man. So there's a lot of different ways that this offence can be committed, and it's a lot broader as to who can be charged. And I think that is an excellent evolution of that kind of charge. So we now call it an offence against penetration. So that can take part in different parts of the body by different objects. And, you know, so it's a broader definition. We've had this evolution in terms of what is an offence of rape. And a big part of it is that it has to have been committed without consent. So it's the act itself and that it was done without consent. And so consent has also been something that has had an evolution in terms of what we understand consent to be.
In my experience, I mean, it's not rocket science, I suppose, but maybe people who haven't been involved in the criminal law mightn't think about this. So I just want to point it out. So when you're defending in a rape case, you really have two broad options. You either say no sexual encounter occurred, or a sexual encounter occurred, but there was consent. And that is often the more common. So you agree that sex happened, you just say that there was consent. And so it's a very common ground where the only thing that is being argued is whether there was consent or not. So,
and not to put any kind of gender stereotypes in place, but traditionally they've called these kinds of cases he said, she said.
Yeah, absolutely.
Because they don't take place in a public forum for the most part, and there's only two people present. And so it comes down to who the jury believes.
Well, often the defendant
for the
isn't
issue
giving
of consent.
but often the defendant, the accused, doesn't have to give evidence. So sometimes it's just whether they believe the victim or not.
Well, that's right, because defence counsel will have cross-examined the victim, and put or tried to cast doubt as to their version.
Correct.
Yes.
And so that's what we saw in the Brittany Higgins, Bruce Lerman case. He didn't give evidence. She did give evidence. And that wasn't a consent case, though. That was a case he said it didn't happen at all, and she said it did.
I also just want to say here, I use the word victim.
Yes.
I know that many
lawyers listening will be
well, many lawyers, but also many persons who have been in that position prefer the term victim survivor.
Okay.
So I
thought you were going to say complainant. Lawyers talk about complainants.
Oh, complainants, yes.
Yeah.
But I use the word victim without any, disrespect to the preferred use of victim survivor.
Right.
Yeah, so it does come down to, do the jury accept that the victim did not consent?
Yeah.
And if they believe that the victim did not consent, then there can be a conviction of that charge.
Yeah.
So it leads us to the other part of defending that charge, which is because with consent, we've reached a point in the last, short while where courts are told, or juries are told, the question is, did the victim consent? So that's their first question. Did the victim consent? And so they listen to what the evidence tells them. And if the victim says, I didn't consent, or I said no, or I pushed them away, or in some cases, I froze out of fear. I wasn't participating. I just was like a statue, all of these things. And so the jury has to look at all of that and say, okay, well, is that a lack of consent? And it's, again, been something that's had to evolve over time, because there have been cases in the past where a jury is told that the victim froze, and that hasn't been seen legally as a lack of consent. So we had to get to a point where that type of understanding was changed. And so that all changed with a case where a guy was charged with offences against his niece. And he said, yes, we had a sexual relationship, but she consented every time. And she gave evidence saying, I didn't know what to do. I just froze every time. He was my uncle.
Yep.
One time he assaulted her while his wife was in hospital having their baby.
Wow.
And so in that case, it was the first time the courts really acknowledged that freezing is a recognised response to that kind of trauma and attack. And so you can't take that as a sign of consent.
Yes.
So that, we've had really good progress in terms of understanding what this kind of trauma can do to a victim, and that there isn't one accepted response, and that you have to take all of that into account.
Yes.
So that's the first question for the jury. Did the victim consent?
Yes.
And that consent can't be obtained by fear or threat or misrepresentation. So a victim who says yes, but because they're afraid, it's not real consent.
No.
And a jury are told that as well.
Yeah.
So that's all great.
Yes.
So you have that question and
Yes.
the jury says, no, well, we accept the victim didn't consent.
Yes.
And then defence might raise the defence to that, which we call mistake of fact.
Yes.
And they have the opportunity under that defence to say, well, the victim may not have consented, but I honestly and reasonably believed they did consent.
Yes.
And then an explanation is provided as to why they held that belief. And this has been a real sticking point when it comes to consent, because that whole premise is that the victim didn't consent. But because of what the accused believed,
that's part
will
of it.
Excuse their
that's part
conduct.
of it.
What do you mean it's part of it?
Honest is the subjective belief of the accused. Reasonable is what another person in that position would have believed based on what the victim was doing.
It's personalised though. Ever since we had a case,
I know the case
where there were particular characteristics such as language difficulties and intellectual capacity. The Court of Appeal said, you're asking, was it reasonable for this specific accused to hold that belief? So it's still subjective.
But it's a reasonableness test, so that it's not completely subjective.
No, it's an objective assessment
of their belief.
Yeah. But it's their belief. And so that they hold that belief.
Yeah, but they have, because you couldn't have it any other way. Because if they didn't hold that belief and they said, but I could have reasonably believed that, well, that'd just be odd, because you didn't actually believe it, so you can't argue that. So it has to always be that they honestly believe that, because that takes away, the mental element of, the malintent, the criminal intent of it. They have to. That's why it has to be the honest belief.
Okay, well, let me tell you some of the cases that have gone through the courts where that argument of I was wrong about consent, but I believed honestly and reasonably that the victim was consenting. Let me tell you some examples, okay? And this is why it's so important we get this right.
Well, but these are cases that are presumably gone in front of a jury, and the jury have listened to the victim, listened to the accused, and then decided.
And so I'm not saying the jury are wrong. I'm saying that the law is wrong. I'm saying that they should not have this opportunity. When you hear some of these, Joe, I defy you.
Well, again, we didn't see or hear the witnesses, so I don't think we just reading off the page we can make a proper assessment of it. But by all means, fire away.
I'm going to. Okay. So the first one was a 13-year-old girl.
Okay. Well, how's consent even an issue in that case? She's, what is it? Well, between 12 and 14, there's a question of consent.
Capacity consent.
And what she was found to have capacity to consent.
I'm guessing so.
Okay. That's where I would have been.
She was asleep in her home. A 21-year-old friend of her stepbrother was staying the night. At some point during the night, he entered her bedroom while she was sleeping. He took off the covers, he pulled down his pants, and he raped her while she tried unsuccessfully to push him off. After that happened, she started sleeping with a metal pole in her bed for protection. When it happened again, Same guy. She tried to grab the pole to defend herself, but couldn't reach it. Her hands were pinned behind her, so she kneed him in the guts. After the fourth incident of that kind, she told a counsellor. So it came to court. He successfully argued the defence of mistake of fact.
Well, again, that based on what you said, that sounds unbelievable.
Okay,
because
so let me tell you another one.
But I don't think he can judge based on those facts. You've just given her side of the story. I don't know what his side of the story was. I mean, I don't know what it could be to get around those facts. But if he's acquitted, he obviously told some story that the jury accepted.
Yeah, I think it was that she wasn't screaming out, or that she wasn't,
Okay, well, I mean, how old is that case? I mean, I don't think any jury nowadays would accept that.
No, but and
she
I
knees him in
understand
the guts. I mean,
I understand that these are not recent cases necessarily, although we have one that is recent-ish. But this is the importance of changing this defence and making sure.
Well, you can't say we should change the defence now based on a case that occurred 30 years ago. It's
That's exactly why we try and change the law, because we see the errors in the past.
But juries have changed now in their approach to these things. As I say, no jury would accept that.
I've got facts about that as well.
Okay,
anyway,
let's hear them.
Next one. An accused man who had brutally beaten his partner with a knife, a chair and a stick for allegedly cheating on him, drawing blood and causing serious injuries before having sex with her, raised the defence of mistake of fact.
Jeepers.
It went on a different issue, but it was open on the facts for him to argue that, the court found. That was 2013.
Is that Queensland?
2013 Queensland Court of Appeal. I should give acknowledgement to an ex-colleague, John Crow. I did utilise some of his research in an article I found of his.
Okay, but again, are you...
I looked up the case.
I'm sure you did. You're always an excellent researcher. My question is, did you look up all the cases of mistake of fact?
Oh, every single case.
Well, otherwise you're cherry picking the evidence. You're just going, I'm just going to look at the problematic cases. There's been 20 cases. I'm going to look at 4 and say we've got a problem. It's like, no, look at all 20.
Okay, we have a problem, Joe.
Well, not based if you've just cherry picked the evidence. That doesn't prove that.
If there is one case like that where...
Okay.
Anyway,
Courts of appeal can make mistakes. That's why we've got the High Court.
Let me bring you to a more recent example, and one probably that some of our listeners would be familiar with because it has been the subject of 60 Minutes or...
Is this a New South Wales case?
Yes, a New South Wales case. The victim in this case was a girl called Saxon Mullins, and the guy was called Luke Lazarus. So she was 18 at the time. She had gone into Sydney with a friend for a night out. She hadn't been 18 for very long, I don't think. She was at a nightclub and she met this guy who we find out later was 21 at the time. They spent some time together on the dance floor, and he then offered to take her to the VIP area of the club. And she was like, okay, well, let's go. But instead, he took her out this door to an alleyway. And there is CCTV footage that shows she tried not to go out. He convinced her, and so she's out in the alley. And so they're out there, and they did start to kiss. And then she said to him, I want to go back inside to my friend. And he was like, no, it's fine. And she said, she tried to move away, and he pulled her back. And then he pulled her stockings and her underwear down, and she pulled them back up and said, look, I really have to go now. And he said, put your fucking hands on the wall. And so she did, turned, and she had her hands on the wall. And he then anally raped her. So she was a virgin at the time. She said that when he tried to penetrate her, firstly, he had some difficulty, and he said something like, oh, shit, you're tight. And she replied, well, what do you expect? I'm a fucking virgin. And he said, oh, shit, really? Oh, what a disappointment. And so he told her then to get on her hands and knees and arch her back. And she said, I just did it. At that point, I was just kind of in autopilot a little bit. I just wanted to go, and this was kind of the quickest way I thought I could leave. I just thought, just do what he says and then you can go. She said it was painful, and she was trying to block it out, and then he let her go.
Again, that, the psychological evidence, as far as I'm aware, is that's another response. So freezing is a particular response, but also just acquiescing to get it over with as quick as you can is another response. And
I don't often dwell on whether, how I would react in that situation, but I think if I thought it meant I wouldn't be physically hurt and I would be released afterwards, I possibly would not fight back, because I know that when you fight back, you're more likely to end up dead. You know? Anyway, so she immediately went to police and reported it, and I'll come back to that. But the next day, this guy, Lazarus, sent text messages to a friend, and they had them as evidence. Said, I honestly have zero recollection of calling you, was a sick night, took a chick's virginity, lol, he wrote. And then the other guy said, bah ha ha ha, nice popping those cherries, tight. And Lazarus wrote back, so tight. It was a pretty gross story, I'll tell you later. So this is how he's referring to their encounter the next day. So she went to the police. That night, she made a complaint. She went through all of the examinations and all of that sort of thing. And so the matter was brought to trial on a rape charge. Part of the evidence that came out during that trial, right or wrong, was that she'd been drinking quite a lot that night. She'd had some drinks in public. She'd had 7 drinks. They ascertained before she even got to the nightclub. She didn't even get to the nightclub till the very early hours of the morning. She was not a seasoned drinker and was, in fact, drunk at the time. She was happy to dance with him. She agreed to let him take her to the VIP area. She kissed him. She initially said no, but then simply did what he told her to. So all of that came out through the trial. But still, he was convicted of 1 count of sexual intercourse without consent, which was the New South Wales terminology for rape, by a jury. And he was sentenced to 5 years imprisonment with a 3-year non-parole period. So, of course, he appealed.
Yes.
And the court found that there had been incorrect legal direction by the trial judge on the issue of consent.
Yes.
And so it was sent back for a retrial. And on that occasion, Lazarus applied for a judge-alone trial.
Yes.
He didn't want a jury this time.
Yes.
He said there was too much media coverage. He was actually the son of the nightclub owner, so they were a little bit well-known.
Right.
And so he got that application for judge-alone, and that's how it proceeded. That judge, who was a woman, found him not guilty of the charge.
Yeah.
She clearly preferred Lazarus's version of events, which was that he thought she was consenting. But she did say that she accepted that Saxon Mullins did not consent. She said in court, I accept that the victim did not consent.
Yeah.
I also accept that he believed she was consenting. He had apparently given evidence along the lines of he didn't raise his voice, he wasn't demanding, he believed that the movement of her body back towards him along with her silence indicated her consent, and that was the reason that the judge found that.
Well, there's that old saying, it's I think originally a legal saying, silence is assent, so that if you are silent, it means you agree. And that wasn't developed for sexual offence cases. It was just a sort of a
well, and that was the case. I mean, they went beyond that in a lot of old cases. I mean, we're talking, it hasn't even been that long since they said that it couldn't be rape if you had sex with your wife.
It's been a while, hasn't it? That wasn't
the 90s.
No, it wasn't. It was like the 50s, I think.
No, it was DPP. It's a case stated by DPP. I'm sure it was a 97 one that definitively said that. Anyway, we've come a long way. Silence is not assent. The judge said she did not take any physical action to move away. The judge also had to decide whether he knew she wasn't consenting, and she said the prosecution hadn't proven its case on that point. She said, I stress that I do not accept that the complainant by her actions herself meant to consent and in her own mind was not consenting, but rejected the prosecution's argument there was no reasonable basis for Lazarus to believe she wasn't consenting.
Well, see, part of the problem, and this is why I've got an issue with affirmative consent laws, is because so much human communication is by body language. It's not by words. And so we know, as I said earlier, psychologists have determined now through interviewing a whole lot of rape victims, that one potential response is that they acquiesce. They just do what they've been asked to do because they just wanted to get it over with, or they think that's the safest way. Inevitable, yep. All of those reasons. So we know as a psychological proposition that occurs. The question then is, in this case, with this person there, when he says something and she does it, you can see that if humans do a lot of their communicating without words by their actions, you can understand why the judge in that case said, well, it was reasonable for him to believe that she was consenting.
And so, but that is the greatest argument in favour of affirmative consent.
Okay, well,
because do you accept, do you accept that Saxon Mullins did not consent to this act?
Well, she says she doesn't consent, so I don't know how you argue with that. You go, she says, I didn't consent. And
okay, and so if that then raises the question
yeah.
of did she or did she not consent, and if that question can be resolved by saying, hey, you good? Are you okay with this? Sure. We're okay to continue. A little tiny sentence.
Okay.
Then why not make that the requirement? Because
the law should never enter the bedroom, or should enter it as little as possible.
Oh my God.
You are asking to change 100,000 years more of human evolutionary behaviour.
Because
so the law should fit to human behaviour. Human behaviour shouldn't have to fit to the law. I really think that it is,
unless it's something like this, where it is so difficult because of that 100,000 years of human tradition to read body language, but people get body language wrong, not just in sexual offence cases, but just in day-to-day life. So when it's something as important and as devastating and traumatic and life-changing as a sexual offence like this, if we can counteract the possible misreading of body language, which gives rise to someone to say, oh gosh, I'm so sorry she wasn't consenting or he wasn't consenting, but I thought they were. If we can counteract that by saying, well, let's just put in a requirement that you need to be sure.
Okay, well, you would have seen this. I've seen this a lot. In fact, I saw it in a case I was dealing with yesterday. Somebody swears an affidavit or a statutory declaration. So that is a process by which they set down their story, they read over their story, they then swear on oath or take an affirmation saying that the story is true, and saying that they know that there's penalties for saying something that's not true, and then later on go, oh yeah, when I said that wasn't true. And then they swear another affidavit saying the first time. If you can go through a process which is so overt about getting somebody to tell the truth and they don't, then saying, are you good to go? And they go, yes. And then that's somehow going to be reliable in every single circumstances. Of course it's not.
What do you mean it's going to be reliable?
You have women who say, or so not women, you have victims who say, I said yes, but I wasn't consenting. He forced me, I felt, so that's an affirmative consent case,
yes,
which your circumstance doesn't work.
There will be times when we still have issues. Okay, let me finish this.
The other issue is you were talking about one sexual encounter in Sydney on one night. How many people in Sydney on that night were having sexual encounters? You are trying to stop. This is on this occasion.
Meaning what?
Well, my point is, the law is about the greatest good for the greatest number. It's not about saving everybody. And you are imposing a law that every single person in Sydney who is having sexual intercourse on that night has to abide by to cover this one case.
Well, there's more than one rape victim.
Sure, I don't know how many came out of that night, but
I understand that at your core you are a criminal defence lawyer, but also at your core you are a father of girls.
I am, and
I do not comprehend, even if you're a parent of boys, it terrifies me to think of my kids being either side of this. And if it can be avoided by asking a question,
Okay, well, it can't. I just demonstrate it can't be avoided by asking a question, because you have victims who will say yes when they actually don't mean yes, they mean no.
And I think it will reduce the uncertainty
I don't think
terms
it will.
of consent.
It will just create a different area to argue on. That's all it'll do.
Anyway, I haven't quite finished with Saxon Mullins.
Okay.
So he was then acquitted of that charge. But the Court of Criminal Appeal later found that she had erred, that judge had erred by failing to state in her judgment what steps he took to determine whether she was consenting, because that had been incorporated into their legislation by this stage. But they refused to grant a third trial on that issue of law because by that stage they said it wasn't in the interests of justice.
So on a judge alone, the prosecution can appeal?
It must have just been that
on
point
that question
of law. Yeah.
Interesting.
It found that it would have been oppressive because it had been 5 years and he'd already been through 2 trials and he had served 11 months in prison. But what sticks in my mind was I saw a photo of him leaving court when he'd been released, and it was like the party had started in the street, you know, and I was just like...
Well, my recollection was it became a bit of a cause celeb about these kind of issues. And the problem is this issue does tend to attract people from the extremes of the sort of the political spectrum.
I suppose so. I think before we come back to affirmative consent, and I know we both have strong feelings there, so you know, we'll stay friends. But but I like how Saxon Mullins talks about it.
Yes.
And this is someone who has the lived experience.
Yes.
You know, there's all of this faith and you know, at the moment we're having a lot of people with lived experience advising on things and getting their opinion. So I think it's got some validity.
Sorry, well, lived experience has some validity.
Yeah, I agree. It's not the only.
It's not some panacea for they're not some oracle of all truth. They have a perspective which is worth listening to.
Correct.
Yeah, absolutely.
And so she said, enthusiastic consent is really easy to determine. And I think if you don't have that, then you're not good to go. All you need to say is, do you want to be here? And very clearly, do you want to have sex with me? And if it's not an enthusiastic yes, then it's not enough. If it's not an enthusiastic yes, it's a no. That's it. And I think, why does it have to be so tricky? I mean,
that sounds, you know, like the greatest mood killer. Just, you know, things are going really well and then you stop and go, do you want to have sex with me? I mean, I think there would be people out killer? I think there would be people out there who would go, you know what, I did until you said that. And then I decided I didn't because the mood has just gone.
And that's fine. Then you don't. There are criticisms of affirmative consent, and yours is one of the ones that's been raised. There was an article in The Australian in January of this year. Affirmative consent might criminalise spontaneous marital sex. So new sexual consent laws could criminalise married couples having spontaneous sex and be misused in divorce cases. The state's peak legal body, QLS, Queensland Law Society, said. They told the state MPs their attempts to replicate consent laws from other jurisdictions which demand affirmative consent could lead to miscarriages of justice. And so it said something like, you know, you might have married couples who then break up and then allegations that they didn't always get consent before sex. And okay, I don't know what kind of psycho is going to bring that kind of a claim.
Well, I mean, I have seen lots of allegations that occur after a breakup of marriage, not in relation to sex, but in relation to domestic violence stuff that appear after the marriage breaks up.
All right. I think that's not a good reason, though, not to have affirmative consent. I mean,
you seem to proceed on the assumption that the only way to fix the problem about, you know, rape, because we're really talking about miscommunication rape, if I could call it that. One party thinks they're consenting, the other party isn't consenting.
No, I'm talking about the availability of arguing a miscommunication.
Okay, but what you're trying to, the mischief that you are trying to correct or to solve is victims who end up having sexual intercourse when they don't want to. That's the mischief that you're trying to.
No, the mischief I'm trying to correct is an accused person who says, oh gosh, so they weren't consenting. Oh, sorry about that, but I thought they were.
But presumably you want the poor victim not to have to go through it by stopping it at its source, as opposed to waiting till it has occurred and then stopping somebody arguing a defence. Okay,
so this brings me back to my initial point about education and awareness and knowledge.
Which is the best way to deal with this, not by changes in the law.
But if people understand that unless you have said, are we good?
I don't think we need that.
Can I finish?
I'm sorry. Go ahead.
Unless we get to that point where that's the default, where people are confirming that there is consent, like we need everyone to understand that then they could be charged and they won't have the availability of the mistake of fact defence.
Which I think is just ripe for miscarriage of justice.
What about all the good it will do for victims who like Saxon Mullins, the court acknowledged she did not consent, but they let him off because he mistakenly believed she did.
So the only way she can be rehabilitated is if he goes to jail.
Okay, let me tell you some of the statistics, okay? So when we think about people who are sexually assaulted or raped, surely you also will acknowledge that a large proportion of them go unreported.
That's what the statistics tells. I don't know how they work that statistic out, but yes, that's what the statistics say.
Okay. This is you choosing whether or not you like
statistics
how do you work out today or not.
How do you work out the people who are not reporting something? I mean, you can work out how many report something. You can't work out how many.
Through their surveys and stuff, people who've been assaulted but haven't reported.
Oh, so they're happy to report it on a survey, but they don't report it to the police.
Yeah, because it's entirely different, Joe.
And and who are they surveying? And how big is the
national
sample size?
Surveys that we've talked about in other
at universities, and you see the questions
across the whole state. The Australian Department of Welfare and
who do they survey? I've never heard of it.
Anyway, I think
I accept that's what the statistics say.
That
yes.
There are a number of unreported.
Yes, absolutely.
So many unreported.
Sure.
So then, and this is just New South Wales Bureau of Crime Statistics for the year 2018. So it is a little bit dated, but they did a tiny follow-up. 5,869 sexual assault incidents were reported to the police in 2018. Fewer than 15% led to a charge being laid. And then of those, fewer than half the cases taken to court resulted in a finding of guilt. So that means that there is, of reported cases, about 7% end in conviction.
I'm not worried about how many end in conviction. Once the trial process starts, I got no problems with it. What is really concerning in those statistics is the number reported and the number that lead to that proceed to a trial. That's the concern, I think. And I think that there's some real work to be done in why is it that complaints are being made that are not followed. I mean, every complaint is not going to end in a trial. I appreciate that.
Yeah.
But the statistic that you've just given, it seems remarkably low. I mean, I gave the statistic in one of our earlier ones about fraud cases, which is that there's a 80% drop-off rate between reporting, and so there are other offences where there's a huge drop-off rate between reporting. But I mean, this is obviously an area of social concern, and so I think it is something that should be looked into. And I know in the ACT they did I don't know what the results, but they did inquire into why it was that the statistics were so low for the number of complaints that ended up in a trial. I don't know what the answer was, but that's what I would be looking at, not the number of convictions. I mean,
okay, but so that was the number in 2018. So then additional raw data that they collected between 2018 and 2022 revealed that the number of reported assaults increased.
Yeah, but what's raw data? What does that mean?
Well, they obviously haven't finished
taking into account
writing
all the
it
things.
all in.
Right,
Anyway.
okay.
Anyway, I'm just telling you what the Bureau of Crime Statistics says.
Yes.
So the number of reported assaults increased from that 5,000 odd to 9,138 with no correlating increase in prosecutions.
Any correlating increase in population?
I don't know.
No.
So I think what we know is that people are reluctant to come forward and make a complaint, that people who do come forward and make a complaint and their matter goes to trial are traumatised again by that process. We know that. And then in a lot of cases, it is a not guilty verdict for whatever reason. And so I just think it is incumbent on us as a community, as people, to address the fact that these offences are occurring, to do what we can to try and
stop the offences occurring.
Stop the offences
Not
occurring.
stop defences that people might argue.
Okay, but so what if this affirmative consent, and when we think about what affirmative consent means, okay, so this is from the new legislation. So it's now part of the law that consent means freely and voluntarily agreeing to the act. So it used to be that consent had to be freely and voluntarily given. And there was questions about, well, what does it mean if it's given? Can it be given silently? Can it be given through body language? Now it's saying there must be a free and voluntary agreement. Okay.
But does that mean it has to be a verbal agreement?
Well, so that's, I guess, open to the courts to interpret. But the
so
flip
they're just
side,
moving the deck chairs on a lotion liner. I mean, this doesn't seem to be making much difference, does it?
But the flip side then is, if consent requires agreement, to argue that you honestly and reasonably believed that they were agreeing, which is a different proposition. Agreeing means you've suggested something and they've said yes. They've said that to raise the defence of mistake of fact, honest and reasonable belief in consent, a belief will not be reasonable if at the time or immediately before the time of the act, they have not said or done anything to make sure that they're agreeing. So the onus is purely shifting to not what did they believe and let's judge them on that, but you tell us, what did you do to ensure there was agreement? And so if that means that people are accustomed to that expectation, if we understand that that's what consent means, and if we teach our kids, for there to be consent, you have to both be agreeing to whatever conduct. So just check in, ask, confirm. Then that means that if that's the habit and someone says, are we right to do this? And the other person's like, actually, I'm not sure. Well, maybe they won't keep going. Whereas, so if we are changing the expectation, the understanding and the practices, and if that means that that is a check to some of these offenders who say, oh, but I believe they were consenting because of X, Y, Z. And now we've said, well, that, we know consent won't mean consent just because you believe they were silent or they wriggled or whatever. If you have taught the next generation and current people that for it to be consent, you have to have that agreement, maybe that will change some of those circumstances where it resulted in a rape.
Okay, good. You've focused all of that monologue on education, and I completely agree with the education. I don't agree it should be the law. I completely agree that we should educate people like that. But if we educated people like that, we wouldn't need to change the law. So why is the tail wagging the dog? Why are we changing the law and then educating? Here's an idea. Let's educate and see if we need to change the law.
Because the attempts to address that issue, like this miscommunication, as you call it, have not been effective.
So what do you mean, as I call it? Why did you air quotes that?
Well,
it is miscommunication. One party believes that they are consenting. The other party is not consenting.
I don't think, like in Lazarus's case, saying, put your fucking hands on the wall.
Okay, he says he didn't say that loudly.
Yeah, but he
might
said
have been whispered in her ear.
Meaning?
Meaning that whispering in somebody's ear.
What, is that an endearment? Put your fucking hands on the wall.
The way that somebody says something changes its meaning considerably, including, are you consenting? Yes. You could say that in a number of ways, which means that you aren't actually consenting even though you're saying yes. So the way someone says something is conveys a meaning just as much as what it is that they're saying.
I just think we can't ignore the fact that the statistics on...
We should never write laws based on statistics. Yes, keep going.
Where's your humanity for the victims here?
The law is there to serve the greatest good to the greatest number. It is not there to save everybody, okay? And it is an opportunity cost of the society that we live in that some victims will not get justice, and I accept that, and that's a sad thing. But, you know.
But it's a lot of victims. In this type of offending, it's a lot of victims who aren't getting justice.
I don't know that's the case.
Well, I just told you that only 7% of reported cases have a conviction. That's where justice comes in.
No, justice doesn't come in on conviction. Justice comes in on valid cases going to trial. The system starting the process.
That's the official definition of access to justice, to have your day in court.
Yeah,
I understand
correct.
that.
Yeah, not on the conviction.
But if we're talking about people whose convictions, whose cases result in not guilty verdicts because of an accused person arguing this mistake of fact that they were wrong about whether there was consent, then I don't think that's justice.
How many times, I mean, where are the stats on this? People argue mistake of fact unsuccessfully. I can tell you I've done a few cases. I've argued mistake of fact on behalf of my client in rape cases a number of times unsuccessfully. And I think you would find it's more often than not people are not successful. And I think if you're going to look at those statistics, you need to take that into account.
I don't think we can say more often than not when the facts are that more sex offences are acquittals than convictions.
Okay. Well, what does that show?
So how can it be more often than not?
Well, if you say more sex offence that go to trial are acquitted than convicted, well, that's not going to tell you much about how often the mistake of fact offence is working.
No, that's right. But it will tell me that it's not more often than not the defence fails.
It might be, it could statistically still be that. But my lived experience, if we want to talk about lived experience, my lived experience is that it more often than not it fails. So
I think we've got a lot going on in our society. We've got this violence against women that's become a focus of the community. We've got youth crime, which has become a focus. I think we need to allow this change in the law to be accepted and embraced.
Why?
Because, Joe, if it means that we are able to circumvent, whether it's teenagers, whether it's young adults, whether it's drunk people in their 50s, whatever, who...
Drunk people in the 50s, where did that example come from?
Sorry, because the ad campaign is very much
young
diverse.
People. Is it?
Yeah, it's very diverse, and it's intended to connect with, all ages, walks of life experience, because it's something that we have recognised everybody needs education on. It's not just a young person issue. It is that we've got these ingrained ideas of what a victim looks like, or how you would respond if you're if you're being raped, and what consent actually means. It's a lifetime of ingrained ideas that are still permeated in society, which is what we need to change.
Well, I think I'd like to see the statistics on that, but my experience is that the victims of sexual offences that I've seen, they're always young. I mean, certainly I've never seen anyone in their 50s.
They are often young.
I'm not sure I've seen anyone in their 40s. And I think that I think that bespeaks exactly what I'm trying to point out, that it's miscommunication. And the older you get, and the more as a man you understand how women think, and the more as a woman you understand how men thinks, the miscommunication falls away, or is less. Not that you don't still miscommunicate, but it's less. And so the chances of it occurring are lower.
I don't think that's true. And I also think we'd have to be careful not to be judging current society on how it might have been in the past, because if you think about the advent of internet dating and online, I think there's a lot more older people who find themselves single. They are back out in the dating scene, and we know that sometimes that leads to...
Sometimes.
Yeah. Well, you're saying it's very rare. I don't know that it is.
I didn't say very rare. I said, in my experiences, that's just...
Yeah, I think... and I also think perhaps a lot of those older victims would be amongst those who are much less likely to come forward and make a complaint in a circumstance like date rape.
How many older victims? This is my point. How many older victims are there? I mean, what are we talking about here?
Well, I didn't look that up, but I'm saying they may be underrepresented in the statistics, because if we know that people aren't reporting, I'd say that someone who's older is less likely to report it anyway.
On what basis would you say that?
For the same reason that people didn't report domestic violence for a long time. There's a sense of shame and responsibility, and like all of these things that are inherent to victimology, The other thing was there have been a lack of convictions, a 2023 UQ study revealed, because even with all of our current attempts or past attempts to change conceptions of this, there is concern that jurors' decisions in rape trials are still influenced by misleading cues, sort of victim stereotypes.
Wow, that sounds very Big Brother. So a randomly selected members of the community are getting it wrong. So they just don't know. They're just uneducated.
Not that. It's that we haven't yet had a cultural shift, that there are still these preconceptions and misconceptions.
How do we know that that's what the jury are doing? We don't know what juries are doing.
A UQ study said that they did.
Did they? Well, okay. Did they go in? Did they interview jurors? And if they did, how did they get permission to do that? Did they? And what did those jurors say? What were the questions asked? I mean, I know some people at UQ. Not all of them impress me as academics. So, I mean...
You can't just discount a study just because you haven't read it.
You were bigging it up on the basis it was from UQ. I'm just
saying where it's from and that it was a 2023 study. That there are things... There was also an article in 2023 about the lack of progress in Tasmania. They have had affirmative consent laws since 2004.
And it hasn't worked. Wow.
Well, a study was undertaken through the University of Tasmania. I don't know if you know anyone there. And the results suggested that judges and counsel continue to rely on pre-reform notions of consent and indications that the prosecution...
So how did they determine that?
I think that was on where they looked at 75 different cases.
Yeah, but how did they determine that people are proceeding on old notions?
I think through the way that questions were asked or evidence was summed up and that sort of thing.
Who's making that judgment call? Oh, that's a preconceived notion.
Well, the
that
person who did the study, I'm assuming. Okay. All right. Well, look, I love that we are so far apart on this issue. That is we should be keeping all of our listeners happy, because if they don't agree with me, then they'll possibly agree with you.
There's
and
always
vice versa.
Yeah, that's right. There's always something that agreed. Sorry, we are agreed that it would be great if sexual offences were stamped out altogether in our community. We just disagree on how we should achieve that.
I think the affirmative consent laws will hopefully be a game changer if accompanied by thorough education and awareness and knowledge. And I think that is where the government have settled, that is something that needs to be done effectively before these laws come in. So that's
what
good.
They've said, is it?
Can I finish with a little, it's not funny, but it is a story that I was happy with the result.
Presumably a conviction. Okay,
no, it was about a judge. Oh. So this is about a Canadian judge, Judge Robin Camp, and he was presiding over a case in 2014, and it was a rape case, and it had been at a party, and the victim and the accused had gone into the bathroom, and there was some sexual contact between them, and then he wanted to have sex with her and she didn't want to. And so she was saying no. She was pushed up against the sink and he pulled her pants down, he raped her, and then, she made a complaint and it came to court. And honestly, when I read this case, I just couldn't believe it. So during the course of the trial, when she was giving her evidence, he said to her, if you really didn't want to have sex with him, why didn't you just push your bottom into the sink so he couldn't reach you? He also said, you should have just kept your knees together.
Wow.
And when he summed up to the jury, he said, sometimes sex and pain go together. That's not necessarily a bad thing. Oh my God. So this is 2014.
Yeah.
Like, sounds like something from the dark ages. Anyway, it must have been Judge Alone.
Stop.
Judge Alone, because he acquitted him.
Really? And then overturned on appeal.
But get this. So he offered the accused this advice when he acquitted him. He said, I want you to tell your friends, your male friends, that they have to be far more gentle with women. They have to be far more patient and they have to be very careful to protect themselves. They have to be very careful. Okay, whatever. I think he needs to go find a trad wife. Anyway, he did end up resigning from the bench just before the disciplinary committee recommended that he be fired.
Yeah.
And he explained it was unconscious bias that was to blame for his offending comments.
There you go.
And he said he had a non-existent knowledge of Canadian criminal law and he'd never actually been trained in sexual assault cases. So it wasn't really his fault. Mm.
Interesting. Okay.
So, excellent outcome. He was removed from the bench, resigned.
You jumped before they
whatever.
pushed him, yeah.
Yeah. But I'm happy to say that is an abnormal kind of direction by a judge.
That isn't.
Is
absolutely.
Absolutely. Yeah. And it's a Canadian case. So
our judges wouldn't do anything like that.
Absolutely not.
Yeah.
But so look, coming back to it, we have made progress. We are working towards a safer place for
Absolutely. For
our young people, our every people.
Mm.
And I just hope we can have some positive effect.
I do too.
Mm.
All right.
Well, that's a good
that's a good note to end
friendly
on.
note to finish
That's
on.
right.
Thanks,
All
Joe.
Thanks, Lizzie. Thanks for tuning into this episode. You can find links to the cases that we discussed in the description. You can also find a link to Guardian Criminal Law, and a big shout out to them for making this podcast possible.
The majority of criminal cases involve people, normal people, people like you, people like me, who find themselves in an unusual set of circumstances that would not usually occur in their life. My name is Mark Savick and I'm here to assist you with your criminal matter. I look forward to hearing from you and being of assistance to you.
If you're interested in clips, you can look at them on Instagram and TikTok. Just search for Justice Matters Pod. See you next episode.